May it please the Court, I'm Mary Elizabeth White and I represent the appellant in this matter, Stacey McMahon. This case starts first with a statute, and the statute is 8.01-217, and that statute is very clear in its mandate. It says, upon a petition of one parent, the court shall, and that's shall, it's mandated, unless it is shown not to be in the best interest of the child, change the child's name. And that's what we have here. We have two parties who had a child together. The mother's name was White, again, no relation to myself. And we have the father, Mr. McMahon. Ms. White had the child and gave the child the name White. Custody litigation ensued, and the parties ended up with a 50-50 custody arrangement. The mother married and changed her name. And there's some argument and some contention that the mother uses her maiden name, the middle name, but the exhibits introduced into evidence in this case don't bear that out. Wirick is the name that she states on her billing statements. In the pleadings for the attorney's fees affidavit, it says now known as. As we go along in the custody and the litigation, Mr. McMahon receives primary physical custody of the child. The child has no one's last name, not the mother's last name, not the father's last name. When it comes to the best interest test, as I was sitting in the gallery listening to this court and this bench, the questions about the key and the ignition and the drinking, I started thinking, and I heard the argument, the common sense argument. And I would like to bring that up. Does it make common sense for a child to go through life with neither parent's surname? On that basis alone, the petitioner, the appellant here, has met his burden, because what happened in the trial court is the trial court looked at the test and lifted that test out of context, and that was the test that was established in Flowers against Cain, but left out the little bit of language that went along with that test that said, we won't change the child's name over the natural father's objection. And in each and every single case, through the case, and there's 5 cases, so they're fairly limited, so we can focus on each one. In each and every one of those cases, the child shared a surname with the parent. In 2 of the cases, the first 2, Flowers against Cain, and then the second case that came along, which was the Bea versus Shelton case, you had the language, the father, sharing the name with the father. The first 3 prongs were sharing the name with the father. And then you had another case that came along, the Rowland against Sherba. But then when you got to the 4th case, the May against Randy case, the language changed just a little bit. Because what happened is the court never even applied that test. It was done on a proffer, much as our case was done on a proffer, where we laid out certain circumstances. And then when this court looked at what happened in the lower court, where the lower court changed the name, they talked about the testimony of the psychiatrist, and they talked about the best interest test, and they also talked about what was in the best interest of the child and the burden that the petitioner must meet. And that burden is by satisfactory evidence.
Okay, counsel. You mentioned common sense.
Yes.
If you ask people just common sense, is it good for a child to go through life? Is it bad for a child to go through life without the name of either? Okay. No question pending yet. And I could see that as a common sense answer if the child had been born that day. That's not the facts we have here. The question, I would turn the question around and ask, from a common sense perspective, is it good for the child to change the child's name when the child is 6 or 10 or 16? And the child already knows what his or her name is and has been since birth. So I don't think that we can use your common sense test to as our guide, because I think that it plays both ways. What are the facts in evidence in this case, looking solely at the child, setting aside the interests of the father, setting aside the interests of the mother? What are the facts in this case showing that it is in the best interest of the child to change the only name she has ever had?
The facts in this case are specifically that this child, again, does not share a surname with the parent. I understand your position, the justice's position, that a common sense argument to the average layman But that's something that's been borne out in each and every case that this court has addressed.
Counsel, you are not addressing my question.
I'll listen again.
It's very simple. What are the facts in this case that give rise to a conclusion that changing the name of a child is in her best interests? I don't want to hear about the father. I don't want to hear about the mother. I want to hear about her.
I would answer that with the child's sense of identity. This is a child, granted, this is a child that is at 6, knows who she is and knows her name. But at 6, if she's old enough to know who she is and what her name is, she's also old enough to question why she doesn't share a surname.
Where's the evidence? Where are the facts? That's a legal argument. Where are the facts in this case?
Facts in this case that the child does not share a surname with the parent, or that it affects the child?
That it affects the child.
The facts that it affects the child, there is, and again, this was done on proffer. There's the testimony or the proffer by the father that the child has asked why she doesn't share a name, that the child has been questioned at school, that the child, there's the picture and evidence that shows that the child has one family with one family name with a different name. There's also the proffer where we established that the father contacted the preschool, was not allowed to even find out if his child was enrolled there. These are parents who live in 2 different locales. The father is in Fairfax County. The mother is local here in the Richmond area. When the father contacted the preschool to find out about his child, he was not even allowed to speak to anyone regarding his child. That could be a safety issue as far as that child.
Okay. So that's the first fact that you've indicated that I would conclude has any correlation or any connection to the child's best interest. Is there any indication that asking about your name shows that it would be in your best interests to change your name? Let me put it this way. I'm named after an industrial city in Ohio whose river caught fire. I asked about that when I was about 8 years old. Why is my middle name Cleveland? And I was told, we actually named after your grandfather, and he was named after the 22nd and 24th presidents of the United States. I was curious about my name. I didn't like it. But it doesn't mean that changing my name at the age of 8 would have been in my best interests. So the fact that she asks doesn't mean that automatically you say, okay, well, we will now change it. She might ask even more if it's changed.
I'll agree with that, but you were offered an explanation and an answer that gave you a connection back to your family, your grandfather. So that river that caught fire in Ohio was no longer paramount in your mind. That connection to your family and your grandfather then became of interest, and it gave you an identity. And that is something that this court has recognized in every single case that's been before it on name change.
Counsel, do you have any evidence whatsoever that a child is better off at the age of 6 to have their name changed than if their name wasn't changed? It would seem to me that if you want to argue your sense of identity, that more harm than good could come from changing someone's name. You identify with that name. You've never had anything other than that name. And suddenly you're being told it's going to be different. That is potentially, I would see that as potentially psychologically troublesome to someone. And so, and that's why we have a judge that heard the facts or heard the proffer and made a finding of fact. And now you're asking us to overturn that. And on what basis? Simply because that's what the father wants.
I would disagree respectfully that is what the father wants, Your Honor, and only what the father wants. What we have, and the court has speculated, and I agree that it is reasonable speculation to say that a child's name being changed could be detrimental. It could also be just as detrimental for a child to grow up not knowing where they belong or to whom they belong.
But we don't know in this case because there are no facts. It could be either. And you're saying one party wants what they think is best, and the other party wants what she thinks is best.
That is correct, Your Honor. All we have is the guidance that's been laid out, and what I have relied upon and am still relying upon is the fact that this Court has consistently said that it is in the child's best interest to share a father's, and then it was changed in Sparrow against Heath, a surname with a parent. So that has been consistent throughout this case law. And what we have left at the end of the day is a child that shares no one's surname. It is certainly new ground, as many of these cases have been with unwed fathers, mothers, people being married, not being married. There's been a progression. But I go back to not even the common sense argument that to have a child that belongs to two families and is in the primary custody of one, and in the short-term primary physical custody in the summer of the other, who doesn't share a name with either parent, can give rise to more confusion and more questions.
Counsel, can you tell me the page in the appendix where the child asked about her name? Somehow I missed that in the facts. And you don't have to take your time to do it now. You can tell me after your rebuttal. In your rebuttal.
Yes, ma'am.
But if we followed, and I understand what the cases to date have held and what the facts in those cases have been, but if we followed that to its natural end, people change their names quite frequently now for any reason or for no reason. What if the father changed his name? Would we be back into court asking that the child's name be changed again because it's then no one's surname? She shares no one's surnames, hypothetically.
Hypothetically, asking whether the father would change his name, I can't even speculate on that.
No, I'm saying hypothetically, if he did, would we be back with the same issue of the child
having
not sharing the same surname?
I understand the court's consternation for that, and I think that was reflected by Justice Kuntz in one of his dissents, that we're going to have people litigating and spending money and putting people in the middle of litigation. If that were to occur, I believe that is something that is not common in our society, particularly for a father. And here, unfortunately, I think we do step into where a woman, when she marries, at times can change her name, which is what happened here. The mother changed her name and changed her name away from the child. Whether the father could do it in the future, I believe that's true. I believe that then, if the father attempted to change the name of the child, the mother could step in again under the statute and object. And I think then the arguments would be valid.
And in light of the potential for the moving target, isn't the best test is what's laid out in the statute, and that is to look at the best interest of the child? Whether to change the name is in the child's best interest.
Yes, and what I'd say is the best interests are defined in two different ways. They're defined with the four-part test.
If they apply.
If they apply. And they've changed from father, father, father to shared surname, and in the last case, the third factor changed somewhat, that said that the surname that the child currently bears, so it's lost that connection to either parent. But there's also the clear language in each of the tests, and that's what I keep relying on, is the fact that it is in the best interest of the child to share a name with a parent. It's always said father as opposed to stepfather, but it is in the best interest of a child. It's a form of identity, and I think that Justice Kuntz even lays that out further in his dissent. And that was in one of the cases here where he said, in this particular case where a child is born out of wedlock, much as we have here, we have two parents with two different names. Can this be a source of confusion for this child throughout the future? Yes, it can.
And at that point, perhaps they could come in and argue that there is some factual evidence that it's in the best interest of the child to change her name. But at this point, what you have is that doesn't really appear to go beyond embarrassment and inconvenience for the father.
Well, the language on embarrassment and inconvenience for the father, and I went back upon the reply brief and looked at the specific language that talks about embarrassment and inconvenience and how we won't change the name of a child over that. And I looked back specifically at the Flowers case and what was said in the Flowers case. And on page 239, in the opinion, it says, what occurred in this case? And all they talked about was the child came home one day with a different name on the paper, and they thought, I see my time is running out.
You may answer.
The child came home with a different name on the paper, and the mother thought it might be better if they shared the name with the surname with the stepfather. And what the court said was, what occurred in this case was the type of minor inconvenience or embarrassment which courts elsewhere have refused to recognize as sufficient to justify changing a child's name over the objection of the natural father. Granted, that language has changed, but in this particular case, this natural father shared a name with the child. It is not what we have here, where the child shares no surname. And it's our feeling, our opinion, that having a child sharing no surname with a parent is not in the child's best interest.
Thank you.
Good morning, Your Honors. May it please the Court, Eugene Oliver here on behalf of the appellee, Melanie Wirick. Your Honors, this is a case that simply, I think it's just one major issue in front of the Court, and that's whether or not the best interest test applies, as was laid out in this Court from Flowers through to Sparrow, and the circumstances at hand. Because if the Court finds that the test applies, based on even the admissions of counsel at the hearing, the Court will have denied the petition for the name change. Likewise, if the Court finds that even if the name test doesn't apply, the four-pronged test, that the other sort of statements made regarding whether or not there has to be substantial reasons, and a circuit court cannot change a minor's name because of minor inconveniences and embarrassment, this Court likewise would be affirming the trial court's decision based on the evidence that was below. To address sort of some of the issues that was brought up by the appellant in terms of what facts there are to say that this name change is in the best interest of the minor child, I would say that there really was none. Essentially, the issue with regards to the school paperwork not being able to be accessed, that was fixed. That came out in testimony that issue was a one-time issue that was resolved. There's no prediction that that's going to even happen again. Likewise, there was some confusion over insurance documents, and the child once said the White family. Going to the point of why this name change is not in the minor child's best interest, it really does go to the sense of identity. This is now a 7-year-old child who has a very strong sense of identity. I would take a little bit of umbrage with the description that this child is left without any attachment to the family, because that's not the facts that were in evidence. The child does share a common last name with her half-brother. Likewise, it is a connection to the mother's family, even if the mother has adopted use of her husband's name. That's still a connection. That's still a family connection. If Addison were to ask her mother, where does my name come from, much like the example of the justice being named after a president, Addison would have gotten the name White based on her family lineage. So it does provide her a connection to a family. And so I don't think that this is an issue where there's just this vacuum of an identity-less child, that it's in their best interest to sort of radically change a 7-year-old's life by changing her name. And then going to sort of the factual issues and why I think that the test is applicable here is because if you look at the evolution in the case law, in Bayah, we were dealing with a new situation, whether it was unwed or wed. The parties in that case could have said the same thing. Well, there was no prior case law that applied this case to unwed parents, so why should the test that was laid out in Flowers apply to us? Likewise, if you take the case in May v. Grandy or Sparrow v. Heath, you're dealing with the circumstance of, well, we haven't applied the test to a mother's right or a mother's name, why should it apply here? And simply what we are asking the court to do is a continuation of what this court's jurisprudence on this issue has been since 1977. And that's when the best interest part of the statute was, I believe, entered in 76. And simply what we are asking is for this court to say, this test does apply. There's a reason we have this test. Because the petitioning party in a name change has a burden to meet. We are giving you a guidepost on how to meet that burden, how to show that the change is in the child's best interest. That's what the four-pronged test in Flowers is for. And I think any reading of the dissents by Justice Kuntz and both maybe Grandy and Rowland versus Sherbert, I don't think are really applicable here towards the evolution, because I think if you read Sparrow, after reading those two dissents, I think Sparrow moves sort of in an opposite direction than those dissents wanted to do. The dissents in those cases focused on sort of a connection with the natural father, whereas Sparrow said there is no presumption that the child should share a name with the natural father, and applied the case sort of going forward, and I think that's the one that I think is really indicative, and I think that's the case that Judge Bellows relied on in the Fairfax County Circuit Court, that the test is sort of applicable and can move forward. And then going to the other things, Your Honor, even if this court were to find that the four-pronged test from Flowers is not applicable to the facts at hand, that there's an implied condition precedent, that and before you can apply the test, the child has to share a surname with one of the parents, I would still point to the language of the court, particularly in Flowers, that said there has to be a substantial reason. The court cannot change for minor inconveniences or embarrassments. If you look at the underlying facts, both in Flowers v. Kane and in Sparrow versus Heath, they're actually extremely similar to the facts that were proffered at court. In Flowers, there was basically a statement that there had been some confusion over what the family name was. This court, in that case, said that's not a substantial reason, that's just a minor inconvenience and embarrassment. In Sparrow versus Heath, there was testimony from grandmother saying that the child's name caused all this confusion because it wasn't shared with the natural parents, and therefore the name should be changed, that it's in the best interest of the child. And this court rejected that argument in Sparrow as well, saying and reaffirming the entire line of cases that there has to be more than just minor inconveniences and embarrassments. So your Justice was going to say something. And Your Honors, I would say that that's really, in terms of where the cases are, that's what I would ask. Particularly in terms of the fact finder at the court below, I think it's very indicative of what the judge below found in these cases, is that the evidence proffered by counsel for the petitioner simply said that what was proffered was a catalog of minor inconveniences and embarrassments. That nothing was proffered showing that any of the prongs were met, and that there was nothing substantial in nature that would suggest that the name should be changed. And I think the trial court there was absolutely correct in terms of that this is just a catalog of minor inconveniences and embarrassments. Likewise, I would also say that in terms of the argument, in terms of the counsel for the appellant, I think also just the misreads the progression of the cases with the emphasis on the natural father and the language there. I think it's clear from reading the line of cases in terms of particularly applying the 14th Amendment's Equal Protection Clause that both parents share, and this is what was sort of validated in Sparrow, an equal right to object. That the burden is on the petitioning party to show that the name change is in the best interest of the child. I think if the position that counsel for the appellant, if this court adopts that position, that's basically burden shifts to the parent objecting. Likewise, in terms of what is the statement, there is no alternative posted to if this court says the four-pronged test doesn't apply. No alternative is presented by counsel of appellant. They would say that even the conditions that are separate from that four-pronged test, that it's only for minor inconveniences and embarrassments, that there has to be a substantial reason. Reading their brief, they reject that as well, saying that the stringent test laid out in Flowers does not apply if the child doesn't share a surname. And that basically it's a sort of per se, if the child doesn't share a surname, then it's automatically in the best interest to share that name. It's burden shifting, and additionally, there's no actual concrete test based on any of this court's prior jurisprudence on the issue that it indicates that there's any sort of alternative. This court would basically be creating a rule out of thin air if it were to grant the counsel for the appellant's argument here and deny what happened at the trial court. With that being said, I believe that would be all of my argument unless the justices have some questions.
All right. I don't think there are any. Thank you.
All right, thank you.
You used all your time.
Thanks.